This morning, the Supreme Court explained why 3 months ago it struck down the dissolution of the Bihar Assembly. And there's no doubt that the court has severely indicted the governor. But beyond saying the Council of Ministers should have verified his report before accepting it, the court seems to have exculpated the government, the Prime Minister and the President. So tonight, as the country digests the Supreme Court judgment, there's growing concern about its apparent silences. Did the buck really stop with the governor, or should the finger of responsibility have pointed higher up the chain? With me from the BJP, former Law Minister Ravi Shankar Prasad. From the Congress Party, its spokesperson and senior Supreme Court lawyer Abhishek Singhvi. And joining us from his residence, one of India's most highly regarded constitutional lawyers, Fali Nariman. Mr. Ravi Shankar Prasad, the Supreme Court judgment has clearly found fault with Governor Bhutta Singh's recommendation to dissolve the Bihar Assembly and said that it was mala fide and misleading. Yet the Supreme Court has not found fault with the government, which accepted that recommendation, made it its own, and acted on it at midnight. Can one really say that the buck stops with the governor and doesn't go higher?
Well, I don't think like that. Let's be very clear about the constitutional scheme. The governor recommends, the decision is taken by the Union Cabinet. Now, the Supreme Court is certainly harsh against Bhutta Singh for what he did. He fully deserved that. The observations of Supreme Court against the Union Cabinet may be milder, but the implications are no less serious.
The only problem is that because the observations are milder, you're relying on implications when you come to the central government.
No.
There's not a clear indictment of the central government.
No, remember, Karan, one thing very clearly. In the last more than 50 years, such serious indictment of the Union Cabinet and of a governor has not come from the hands of the Supreme Court. Then what I say, the bottom line is, Bhutta Singh misled the Union Cabinet and the Union Cabinet misled the Rashtrapati ji. That is how I see it.
Mr. Nariman, the assumption that underlies the Supreme Court decision to blame the governor and not the cabinet is somehow the belief that the cabinet was simply a stamping authority or a forwarding agency and neither did nor was required to exercise its own mind and judgment. Are governments expected to accept a governor's recommendation to dissolve an assembly, and I should point out a Bihar assembly that in fact had never convened, without exercising their judgment?
Well, I can tell you what I heard this morning, since I have not read the text of the judgment, but I only heard what the Chief Justice and the other two judges read from their judgments. And from what they read, I conclude that they have found that the reports of the governor were motivated, mala fide, and perhaps for oblique political reasons, and therefore they have said that the decision of the Council of Ministers for recommending to the President for dissolution was also therefore invalid. They have not gone further at all. I don't know what the arguments were, but presumably we must accept the position that that's where the buck has stopped, namely at the lowest level, the level of the governor.
But can I interrupt, sir? Can I interrupt and point this out?
Yes.
The Supreme Court certainly seems to accept that the buck stops with the governor, but you know our constitutional system. You know that in fact the cabinet has to either accept or reject the governor's recommendation. In this instance, the cabinet accepted it and forwarded and acted on it. So surely the buck then carries on up the chain. Shouldn't the Supreme Court have been equally critical of the higher level of the chain?
Well, I don't know how they phrased their judgment. I mean, one has to read it, but I would certainly think that the Council of Ministers would have to apply their mind to what the governor has said. There's just no doubt about it. Now, one cannot put the blame entirely on the governor. The Council of Ministers has to take moral responsibility for what the governor has done. And if the majority decision is right, and mark you, Karan, there is a dissenting view, very strong dissenting view of two judges of the Supreme Court, Justice Balakrishnan and Justice Prasad, who take the view that there was no mala fides of the governor. So you have to weigh that along with what the majority says. Okay. But as under constitutional law, it is the majority judgment that is binding, and according to the majority judgment, I believe that the governor must go.
Okay, let's, Mr. Singhvi, look at it like this. A moment ago, you heard Mr. Nariman say that the central government shares moral responsibility. The blame cannot be pinned solely or only on the governor. Part of the blame comes to the government itself. Let's for a moment just look at the facts. It was well known to the central government that Nitish Kumar was poised to form a government, or to at least put in a claim that Lalu Yadav didn't want this to happen, that a cabinet was summoned close to midnight, and then the recommendation of that cabinet was forwarded by fax to the president out of the country at 2 in the morning. Now that's not normal behavior. That is a cabinet acting in extreme haste. Surely on those facts alone, the cabinet becomes culpable for some guilt.
In my view, it is correct to state that a decision of the Government of India and therefore of the cabinet has been reversed by the court. There is no doubt about that. To that extent, a government decision has been reversed. But that's not the issue at all. There are two issues which are being missed here. Every judicial declaration of invalidity ex post facto later on by a court judgment is not the same as legal or moral culpability. If that was not so, Mr. Vajpayee and Mr. Advani should have resigned every time the Supreme Court gave a stinging judgment on Ayodhya, which it did during the NDA regime. If that was not so, they should have resigned when the Supreme Court reversed their Gujarat election judgment by a 5-judge bench. The point is, the central government takes responsibility. It is not shirking. It is its own decision which is reversed. But equally the point is, they believed what they saw. Subsequently, a court has found that belief to be wrong. But an error is not the same as malafide. It is not the same as perversity. It was a bona fide error. The central government has not started out.
Let me bring in Mr. Nariman at that point. Mr. Nariman, you've heard what Mr. Singhvi says. In effect, he's saying that the blame lies with the person who gave the advice, not with the party that acted on the advice, although the party had a right to refuse the advice. That's a very strange position, because if the party had a right to refuse the advice, then in accepting the advice and acting on it, they make it their own position and they are equally to blame.
No, I take the view that the Council of Ministers has definitely a moral responsibility to have vetted the reports of the governor and not been so precipitate in the decision and in the communication of that decision overnight to Moscow. And that's the feeling that everyone has, I believe. I mean, everybody who is who knows anything about it.
Can I press you a little further? You're talking about the Union Cabinet as a whole having a moral responsibility. Specifically, what about the Home Minister who would have presented the recommendation of the governor to the cabinet? Did he not have a special individual responsibility to verify the recommendation, to ensure that it was based on proper ascertainable facts, and only then give it to cabinet? And if he didn't do that, then is he not specially responsible?
No, I don't think so. No, you can't split up the cabinet in that fashion. Please remember, the Constitution speaks of the Council of Ministers with the Prime Minister at the head. So if the buck stops with the governor, then the next round is with the Prime Minister. There is no splitting up of the Council of Ministers. The Council of Ministers acts collectively, and what each minister, and just a minute, what each minister says or does not say at a cabinet meeting is cannot be disclosed, and it's totally confidential.
In which case, very quickly, if the buck stops at the next level with the Prime Minister, as you said a moment ago, then does the Prime Minister have special individual responsibility for convening the cabinet at midnight, for faxing a recommendation to the president when he was out of the country at 2 in the morning, and for acting in such extreme haste?
I would say it is the collective responsibility of the Council of Ministers with the Prime Minister at the head. Of course, the Prime Minister is part of the Council of Ministers. In fact, he is the lead minister in the Council of Ministers. Therefore, this precipitate action must lie both at the door of the Council of Ministers with the Prime Minister at the head. You cannot get rid of that.
Mr. Abhishek Singhvi, before I come to Mr. Prasad, I want you to answer what you've just heard Mr. Nariman say, that the cabinet cannot escape its moral responsibility, it has to share in the guilt with the governor, and that the Prime Minister cannot escape his responsibility as the head of the cabinet. How do you respond to both those points?
I've already made the point that invalidation is not the same as culpability, but the more important point about your precipitate or hasty action, you must realize that today there is a judicial overruling. and the judiciary's final verdict is final. But you have to transpose yourself back contemporaneous in time to that time. And at that time, the cabinet did what it believed in, and what it believed in was a report which said that there was precipitate,
except for the fact it had no right to believe in
it
the
had to
report.
stop defection.
No, but forgive me, it had no right to believe. It had no right to believe in the governor's report without verifying it.
That's what the court
To
is saying.
believe in it
When the
without
court is
verifying
saying-
it is to be guilty of a terrible lapse, a lapse of naivety, if at the least.
No, there is a difference between a bona fide belief in the report of a constitutional authority subsequently found fault in by a court judgment, but it acted as it did because there was precipitate immediacy and urgency. And today, in ex post facto, you can say it is wrong, but at that time, they believed that stopping defection was a valid thing to do. It sounds like a court which has now said that that's not a valid consideration for a 356 proclamation.
All right, that's your argument. It sounds like a lawyer actually hair splitting, but it's not for me to comment, it's for the audience to decide. Let me put this to you, Mr. Ravi Shankar Prasad. Mr. Advani has today called for the Prime Minister's resignation. How come he hasn't criticized the Supreme Court for failing to indict the government in its judgment? After all, if the Prime Minister should be resigning, then equally the Supreme Court should have gone that one rung further up the chain, which it didn't. So why hasn't Mr. Advani and why hasn't Mr. Jaitley and why aren't you doing the first immediate thing of criticizing the Supreme Court judgment for falling short?
Karan, I am amazed by this argument. I am sorry to say that. Supreme Court is never criticized. They speak by their judgment. And the judgment is very clear. They have only used milder language. And by the way, let me recall.
Euphemism, not milder language.
No, sorry.
And euphemism is the way of actually avoiding saying things bluntly.
Let me say, please let me say something. They said they were misled by Bhuta's report. They did not make independent verification required by the Constitution, which led to the wrong advice being given.
No, forgive me. What in fact the Supreme Court says, and I want to quote it to you, is that the Union Council of Ministers should have verified the report before accepting it as gospel truth. But they don't go on to conclude, as they could have and perhaps should have, that in failing to verify the report and yet acting on the basis of an unverified report, the government was naive, worse still, it was knowingly misled, worse still, it failed to do what it should have done, which is verify and exercise mind and judgment. Now, it doesn't go that far. Why aren't you criticizing
I
the
am
Supreme
sorry
Court?
to say that the meaning of the Supreme Court words are the same. And by the way, don't forget that in Sariska, Manmohan Singh said that the worst form of horse trading was going on in Bihar. And to the
But
Supreme
we're not
Court.
talking about Manmohan Singh, we're talking about your failure in the BJP to not criticize the Supreme Court.
You know, I'm sorry, this amazing argument, surprising argument, we never criticized it to go by the judgment. And by the way, let me say one thing, I must clarify. Manu Singhvi is about the NDA regime. Did any meeting take place in the heat of night at 12 o'clock? He alleged that. I must clarify.
No, you don't have to. Let's not get into polemics. Let's stick to the issue because time is limited.
Never any meeting took place at the dead of night.
Mr. Ravi Shankar Prasad,
President was misled.
Let's stick to the
Never
big issue
like that.
because time is against us. I'm going to take a break at that point. I want to come back after the break and with my three senior lawyers who are also three senior politicians, I want to ask, is the Supreme Court right in not pointing the finger of responsibility to the President? Because after all, he was the one who eventually signed on the line, and Governor Bhuta Singh at least claims that he could have refused to do so. And previous presidents have actually done just that. So, the question after the break, does the President also have a case to answer? See you in a moment. Welcome back to India Tonight. We're discussing the Supreme Court's Bihar judgment delivered earlier this morning. Mr. Nariman, in your article in the Tribune on the 29th of May, you said it was the duty of the President to ensure that the advice given to him was not driven by petty party considerations, as had been alleged by the opposition, but by higher considerations of state policy as asserted by the Council of Ministers. And then, pointedly, you added, this he could only do after he had fully informed himself of the contentions on both sides. But the President denied himself this opportunity. In this he erred. He gravely erred. Are you surprised that the Supreme Court doesn't seem to agree with you? The Supreme Court hasn't pointed out to any erring on the part of the President.
You are absolutely right. The Supreme Court has said nothing about Article 74, the proviso, which says that the President has always the right, unlike governors, has the right to send back a recommendation of the Council of Ministers once, but once only, for the reconsideration of the Council. and this has happened in the past, and it has worked. And that was what prompted me to mention this in the article long before the Supreme Court verdict.
So in fact, would you then say that just as the Union Cabinet has a moral responsibility to bear, so too does the President?
I'm afraid so.
And has the Supreme Court been less than complete and honest in failing to make that point?
Well, let me put it this way, Karan. The Supreme Court judgment is a fractured judgment. It's a verdict which is a split verdict. It's a 3-2 verdict. And the judgments which are now, which we never knew about until this morning, about the two other judges who take the view that at the bottom line the governor was not mala fide, therefore the Council of Ministers had no responsibility, therefore the President had no responsibility. So it's a matter of arithmetic now, 3-2, and although under the Constitution the judgment of the Supreme Court is binding, and it happens to be a majority verdict which happens to be binding, yet the circumstance does, it's a matter of some moment that two senior judges of the Supreme Court have taken an entirely contrary view.
Quite right, there's no doubt about that, but the majority judgment which comes to the conclusion that the governor was mala fide inexplicably stops short of...
Has not gone far enough.
Quite right.
You're quite right.
You agree with that?
Yes, it has not gone far enough. It ought to have inquired, because if it took upon itself the duty of inquiring, and this is where you see you have to bear in mind, and that's perhaps one of the reasons why Justice Verma, a very distinguished and very senior judge in Bomaya's case, said that these matters cannot be judged, and they have no judicial standards to judge them, and the court must not judge them at all. And that was his point of view.
Quite right.
But since they go into it, then if you go into it, then I think the inquiry ought to have been more complete than it apparently has been.
Mr. Singhvi, one reason why the inquiry should have been more complete and should have pointed the finger of responsibility not just to the Union Cabinet, perhaps all the way to the President, are the facts of the case. The President was out of the country. He received the recommendation by fax at about 2 or 3 in the morning. He had no time effectively to seek advice from legal experts. He had no time to consult protagonists or opponents of the decision, all of which he could have, arguably should have done. He could easily have deferred the matter for a day or 2 or 3. The world would not have ended had he chosen to do so. Yet he fell into the trap of acting in haste, and as a result, as Mr. Nariman says, he erred grievously. Now, surely you accept that the Supreme Court judgment should have gone all the way and completed its logic. It stopped its own logic halfway.
No, I think this whole approach is wrong. Firstly, I think having received a judgment at the apex court level, that too, and a 3-2 verdict, as Mr. Nariman rightly says, you can hardly sit today and dissect it in a way so as to suggest that it should have been written like this or should have concluded that.
Why not?
That is purely speculative.
Why can't you do that?
Because judges give judgments on the basis of facts and arguments presented before them, and ex post facto for us to decide what they ought to have done.
But there is an implicit logic in the criticism that needs to be completed. If you don't complete your own logic, then you're guilty of cutting yourself short.
But you haven't allowed me to complete. Let me come to the logic part. That's the second part of my answer. Your whole premise is, repeatedly, a meeting in the night, a communication with the President in Moscow at 2 o'clock, no time, etc. What you are forgetting, and that's the crucial part I want to emphasize, is that the Cabinet and the President were given to understand on the basis of a report that there was immediacy and urgency as far as defections were concerned. Now that was the immediacy, and that explained the time frame. However, they also believed that without their immediate intervention, things would go wrong.
Can I interrupt?
It was constitutionally valid.
Can I just take 1 minute more? I'm interrupting for a specific reason. The Supreme Court has pointed out that it wasn't for the governor to go into the issue of defection. That was for some other authority to do. So even that premise is wrong.
Can I suggest humbly that I also know the Supreme Court judgment? Allow me to complete my point. Allow me to complete my chain of thought. It will take hardly half a minute. and that chain of thought is this. The Supreme Court has noted the facts by which the Council of Ministers and the President acted on their perceived urgency of the situation. Now, they thought that stopping of defections is a valid, relevant constitutional criterion. Today, the apex court holds that that is not a valid criterion so far as President's rule is concerned. But that is wisdom of the Supreme Court today. At that time, bona fide they believed that their attempt to stop defections on the basis of a governor's report is a bona fide exercise of their power. Now, you cannot judge a bona fide exercise of power subsequently unless you hold it to be malafide.
Well, I'm afraid you can. It's your opinion that says you can't. But let me leave that there. Let me bring in Mr. Ravi Shankar Prasad. Once again, Mr. Prasad, as I pointed out in the case of the Union Cabinet, the Supreme Court hasn't gone as far as it could have. You've heard Mr. Nariman say that the very logic of the majority judgment required that you go up the chain. You're very critical of the Union Cabinet and the Prime Minister. You've demanded his resignation. Why are you not so equally outspoken of the President?
Well, let me say this. First of all, let me correct my friend, Mr.
No, answer my question. Yes, we have running out of time. Answer my question. Why are you not so
please allow me to answer.
President?
Please allow me. Please. A, you have a point. The President ought to have waited and consulted legal luminaries. But don't forget the Indian scheme of constitution. He acts on the aid and advice of the Council of Ministers.
But he has the right to send it back once.
Surely.
Narayanan did so.
What would the President do when he is confronted with a situation that the Cabinet is meeting at night? Waking him up at 2 o'clock in the night. The President was genuinely misled into believing that yes.
The President had a right to say to the Prime Minister, I will answer in the morning or I will answer when I return to India.
But I am only talking on behalf of the President. I would feel that he was genuinely misled that this matter is something really urgent. And here was a case.
It sounds to me as if the President allowed himself to be misled rather than was misled. And there's a very important difference between the two. You could be if you wanted to be critical, but you're not because for some reason you believe that subtlety and politeness require that your criticism stop short of the high office of the President. Surely, in the interest of Indian democracy, you want to ensure that this doesn't become a precedent for future presidents signing on the dotted line in the wee hours of the morning when they're not in the country. That's the reason for criticizing the President.
No, what I am simply telling you, this can be also put in this way, that the President was genuinely persuaded that the matter is really urgent. And here was a case where everything was done for covert political oblique consideration to prevent Nitish Kumar from coming to power there. And therefore the Supreme Court has gone into castigating all this, and therefore I repeat that the Prime Minister must own the moral responsibility and resign, and the governor be sacked.
All right, gentlemen, we've aired the subject fully. Quite clearly, this is not an issue on which we're going to come to any clear judgment or agreement, but we've raised fundamental questions, and I believe Mr. Nariman has gone further than anyone to raise fundamental doubts. Well, my thanks to all three of you for joining me, and my thanks to you if you've been watching. Goodbye, good night.
Founded in 1935, nationalized in 1969, over 1,300 branches